The Supreme Court of North Carolina issued a pair of rulings this month with interesting implications for constitutional rights. Both were unanimous opinions, both authored by the Chief Justice, Paul Newby. And joining us to talk about both of the cases is John Guze, Senior Fellow in Legal Studies at the John Locke Foundation. And John, first of all, let's start with the one that probably got the most attention. That is Dominski versus State Board of Education. This deals with the right to access to a sound basic education. But unlike most discussions of that topic, which have to do with school funding, this one dealt with making sure that the schools are safe from harassment and bullying. Very interesting case.
It was interesting. And it was, in my opinion, it was kind of a hard call. And I'm surprised that the Chief Justice succeeded in getting a unanimous decision on this. I think that's sort of a testament to his authority as a constitutional scholar, because one of the interesting things about Justice Newby is it really is a scholar. He co-authored the primary source on North Carolina's Constitution, and he cites it several times in this opinion, I think. And anyway, that's an interesting result, and I'm glad to see that he's got that kind of influence over the court.
So we're not going to get into many of the details of the case, but basically there were three members of a family, went to an elementary school in Pitt County, and the students were subjected to, if the court records spell out the facts correctly, really horrendous types of abuse from fellow students. They complained to teachers, principals. Eventually, the school board learned about it. Not much, if anything, was done about this bullying and harassment. And so a year after the parent took the kids out of the school, she sued and said, look, the Constitution says my kids get access to a sound basic education. You didn't do anything about this bullying and harassment. This is something that would violate their access to the sound basic education. An interesting argument. As a person who looks at laws and the Constitution, were you surprised to see that courts went along with that argument?
Well, I wasn't surprised because we've already seen the courts in North Carolina, willing to interpret this clause of the Constitution in a way that does put some responsibility on the schools to do certain things. And, we know that in the Leandro case, they said that there has to be sufficient funding to provide such an education. And certainly if you can mandate that a certain amount of money has to get spent, you can certainly mandate that the school has to protect kids from this kind of harassment. Because if the facts are as they are alleged, it was just appalling, as you say. And the fact that the school wasn't able or willing to do something to put a stop to it is about as bad as it can get as far as preventing somebody from getting a proper education.
Now, in this particular case, it's been several years since the suit was filed. The kids are older, and I'm not sure what will happen as this goes back to a trial level. But it sounds as if this puts school systems across North Carolina on notice that if you're not really paying attention to bullying and harassment, you could be subject to a legal suit based on a Supreme Court precedent.
Absolutely. They're going to have to do something to deal with bullying, or they're all going to be subject to lawsuits like this one. Now, it's important to remember, however, that what we've got here, this was a motion to dismiss. The school said, we're not liable here. We've got immunity, and you have to just suck it up. The court said no, and no. So it goes back down to the trial court to decide whether the facts really are as they were alleged. A lot could happen between now and when there's a final judgment in the case. But still, it's a win. And the way that Justice Newby wrote his opinion makes it very clear that any kind of bullying that doesn't get properly addressed by a school system is going to open them all up to liability. No question about that.
Well, this certainly potentially opens the door to other lawsuits linked to this basic constitutional right to access to a sound basic education. Let's switch gears and talk about the other opinion, also unanimous, also authored by Chief Justice Paul Newby. It's gotten a little bit less attention, but certainly deals with a right that is not only in the state constitution, but certainly something that has been a part of our rights as Americans, and even back before that was the rights of the Englishman, the right of petition, which is implicated in a case with kind of a long name, Cheryl Lloyd Humphrey Land Investment Company versus Resco Products. In this case, we basically had the owners of a quarry who had representatives speak at a public hearing, talked about their concerns that a potential development might be impacted by their own quarry. And later on, those comments helped scotch part of a development deal. So the company that wanted to make the development deal sued the quarry owners. And then the Supreme Court says, no, you can't do that. This is people speaking at a public hearing. This is their right to petition the government. There shouldn't be any lawsuits of this type. What did you think about this ruling?
Well, a couple things. First of all, this is why I love reading Justice Newby's opinions, because he's such a scholar, and he does provide a very concise history of the right to petition, going all the way back to Magna Carta and taking it in just a few sentences all the way up to the North Carolina Constitution of 1776 and on up to our current Constitution, which was great. It's just a pleasure to read that kind of analysis, and it's always very helpful. Nevertheless, as with the other case, I was surprised at not at the outcome necessarily, but to see a unanimous decision along these lines. Again, it shows how much authority on constitutional matters Justice Newby has, because on its face, this is not such an easy call. You know, this was also a case where what they were reviewing was a motion to dismiss, or a ruling on a motion to dismiss. And so they have to take the allegations at their face when they're reviewing a motion to dismiss. And in this case, what was being alleged was that the quarry owners maliciously lied. And it's interesting. I don't say it's wrong. I defer to Justice Newby on this, but it's interesting that this constitutional right to petition the government would rise above and be would be binding, even when it comes to something as malicious, as bad as what is accused here. And in fact, I'll just read it. He says, neither the maliciousness nor the falsity of the statements here have a bearing on our analysis. That's an extreme statement. That shows just how important, in his view, the right to petition is, and how firmly entrenched it is at the center of our constitutional order here in North Carolina. So another interesting decision, and impressive that it was unanimous.
And in fact, one of the other comments made in Justice Newby's decision that will be familiar to anyone who's familiar with First Amendment law on free speech, and that is, if you have this malicious, terrible speech, the way to combat that is more speech. And in fact, he notes that in this public hearing, once the quarry owners made their comments that have been branded by the plaintiffs in the case as malicious, the plaintiffs responded that, no, what you're saying is wrong. No one went along with what the quarry owners said. So in this case, the speech that was on the side of right seems to have won out.
Yeah, that was one of the very charming things about this opinion, because that's exactly right. The antidote to bad speech is good speech. And in this case, good speech won out, at least to the extent of persuading the town of Hillsborough to rezone the property.
One last thought before we wrap it up, and that is, we saw a couple of cases this month, both written by Justice Newby, both involving some basic constitutional rights. In the Dominski case, a state constitutional right. In the case of Cheryl Lloyd Humphrey, a case of not only the state constitution, but the federal constitution. Do you expect that, given the fact that Justice Newby is such a constitutional scholar, we might see more rulings like this coming down during his time as Chief Justice? These are really the first couple that we can think of since he's become the chief.
Well, I certainly hope so. They're always interesting and fun to read, and I look forward to reading many more of them.
Well, if we have any more decisions of that type, we know that one person with whom we will consult and chat through video is John Guze. He is the Senior Fellow in Legal Studies at the John Locke Foundation. Thanks so much, John.
Thank you, Mitch.